Trey, I have received and reviewed your motion in its entirety, and at this time I will listen to your argument on behalf of your client.
Thank you, Your Honor. As Your Honor has seen the stipulation motion for post-conviction relief, this is a motion that has been a long time in the works. There's been considerable negotiations with the district attorney's office as to a fair and proper disposition of the sentence, and in this case. The stipulation calls for an amendment, and frankly I'm somewhat confused as to whether it should be called an amendment or vacation of, or vacating the first degree sexual assault conviction to a count of third degree sexual assault. Mr. Miller is prepared to enter a plea of no contest to third degree sexual assault. Under the stipulation, the other counts would remain the same. As you will recall, the court sentenced Mr. Miller to 42 years in 1998. The grounds in the post-conviction motion go towards the belief that at the time of the original sentencing that the practice was there would be a realistic chance for release in a much less time than that. The motion also talks about, and through the stipulations and through the negotiations with the other party, the state, there's other grounds that exist that are not detailed in the motion, but they are, I think, sufficient for the state and us to believe that this is a fair disposition of those grounds that will avoid the likelihood of other litigation that would be extensive and long. And I think it's a fair disposition. I think the court has the authority to grant this. And I would simply ask that you use your authority to administer justice and to grant the relief here. Under this relief, Mr. Miller's sentence would be reduced to 21 years. The stipulation that we had sent in with the motion had to be altered slightly because of discussions with the registrar at the prison where Mr. Miller has been listed in a correctional institution. So there's a slight change on that. I believe you've been given a copy of that change. The original one that was sent with the motion asked for a sentence of 21 years, 9 months. There was a 9-month battery sentence that was originally, we had agreed to make that, it was originally ordered to be concurrent, we had agreed to make that consecutive, but that would be going back to a concurrent term, making the total sentence 21 years, period, instead of 21 years, 9 months. Mr. Lipsky had signed that stipulation. I think we maybe just got a copy of that. That's the only difference of the stipulation that was sent with the motion with the current one that's been signed by all the parties. Mr. Miller has signed this. Under the terms of this, Mr. Miller would be on parole for almost 5 years more. He would have strict conditions that are set forth. We have talked to the parole officer in this. Some of the obvious conditions: he would have no contact with Connie Bargovich. He would no alcohol, which was involved to some extent in the original offense. He would be living with his parents. That has been approved by the parole officer. We believe that it is a fair and just settlement of this case that has hung around for a long time, and we believe that this would settle it in a way that is obviously to the satisfaction of the state and Mr. Miller. It's been some give and take on all sides here, but we think it arrives at a just disposition. So I would ask you to approve of the stipulation. I'm somewhat unclear as to whether we're calling this a vacating. In any event,
let's stop right there. This is just a practical matter because Ms. Rancinici is actually the person who has to produce
prepared to enter into a colloquy on those charges. And in my opinion, it is knowing and voluntary, and he's prepared to do that.
Mr. Prey, I believe that the proper way to proceed is to amend the sentence.
Okay.
And, Mr. Lipsky, the court has received and reviewed a letter from the victim.
Yes, that takes care of our requirements under 950.
I believe that the 950 requirements of the state have been met. The court has received and reviewed a victim impact statement, and based upon that, Mr. Prey, you may proceed. If you present the plea questionnaire, we'll go with it.
Okay.
Ask your questions.
I'll note, Your Honor, that I did have the jury instructions to those offenses.
For the record, Your Honor, the state would agree with the amendment as mentioned by the court. I believe that's part of the stipulation. And we'll go straight forward with the term amendment and that should clarify everything.
First off, it's a motion on behalf of the defense to grant an amendment. This is a joint recommendation, and the amendment is granted. So what is now before us is a violation of section 940.225 sub 3 and 939.63 sub 1C. This is sexual contact without consent and the threat of use of weapons. Mr. Miller, this is a new plea, and your attorney has presented me with a plea questionnaire and waiver of rights, which I have reviewed in detail. I'm going to re-ask those questions, and it's going to be in a yes or no format. Mr. Miller, first off, Mr. Prey, how does your client plead as regards the violations of 940.225 and 939.63?
He pleads no contest to each.
Right. And Mr. Miller, is that your decision?
Yes, it is, sir.
Did anyone make any promises or threats to get you to do that?
No.
Mr. Miller, are you now 53?
Yes, I am.
And you had 13 years of schooling?
Yes.
You do have a high school diploma, is that correct?
Yes, I do.
You do understand English, is that correct?
Yes, sir.
Do you understand the charges you're pleading to?
Yes, I do.
You are not receiving treatment for mental illness or disorder?
I am not.
You have had medications in the last 24 hours, is that correct?
Yes, I have.
Does that affect your ability to understand these actions in any manner?
No.
Mr. Prey, do you agree?
I do, Your Honor.
The most important questions, Mr. Miller, regard your constitutional rights. Did you discuss your constitutional rights with your attorney?
Yes.
Have you decided to give up your right to a trial?
Yes, I have.
Have you given up your right to remain silent, and you understand that your silence could not be used against you at trial?
Yes, I have.
Did you give up your right to testify and present evidence at a trial?
Yes.
Did you give up your right to use subpoenas to require witnesses to come to court and testify for you at trial?
Yes.
Did you give up your right to a jury where all 12 jurors would have to agree that you're either guilty or not guilty?
Yes.
Did you give up your right to confront in court the people who testify against you and cross-examine them?
Yes.
Did you give up your right to make the state prove that you're guilty beyond a reasonable doubt?
Yes.
Did anyone make any promises or threats to get you to give up your constitutional rights?
No, sir.
you understand the maximum penalty for this is 5 years plus 4 years as an enhancer? Do you understand that?
Yes, I do.
Mr. Miller, I see your signature and the date 12/16/13 on this document. Did you sign that document?
Yes, I did, sir.
Did anyone make any promises or threats to get you to do that?
No.
Mr. Prey, is that your signature?
Yes, it is, Your Honor.
Are you satisfied that your client is freely, knowingly, and intelligently entering his plea?
Yes, Your Honor.
Based upon Mr. Miller's responses to the court's questions and the court's review of the plea questionnaire with Mr. Miller, the court is satisfied that he has freely, knowingly, and intelligently entered his plea, and therefore the court finds him guilty of the sexual contact without consent with proper use of a weapon. Mr. Prey, is there any further argument you wish to make?
No, Your Honor. It's a joint recommendation as a sentence.
The court has reviewed the entire file, and the court first wants to state for all persons that this is not a capitulation to confabulation. This is a determination based on facts, and the facts presented in the stipulation for post-conviction relief serve two purposes. One, the court, in reviewing the victim's impact statement, finds that this is in the best interest of the victim. The court also finds that this is the best opportunity to meet the original intent of the court in sentencing, that Mr. Miller engaged in rehabilitation. I believe that this acceptance of this agreement meets both of those purposes, which in some ways have been frustrated over time. I believe the court has the authority to grant this motion. As findings of fact, the court adopts by reference the facts set forth in the stipulation, makes those as facts upon which the court can make a finding. Mr. Prey, the order that you submitted to the clerk just recently, that is the proper order that you're asking the court to accept?
Yes, Your Honor.
Based upon the stipulation of counsel and the court finding that the facts are appropriate to grant the stipulated motion, the court accepts the stipulated motion for post-conviction relief signed by the parties on December 16th, 2013. Accordingly, the court amends the sentence in Donald Miller's sentence, count 4 for first-degree sexual assault, Class B felony, in the above case to a conviction of third-degree sexual assault, Class D felony, enhanced by the use of a dangerous weapon, with a sentence of 9 years incarceration being served consecutively to the sentence in count 2. All other counts in 97 CF 60 remain as stated in the January 20th, 1998 judgment of conviction. Mr. Prey, is that the appropriate document?
Yes, it is, Your Honor.
State believes it is also, Your Honor.
The court grants the motion.
Thank you, Your Honor. I think do we need an amended judgment of conviction?
We certainly do.
Yeah.
We need to inform Ms. Ransonisi in detail what exactly needs to be contained in the document that the Department of Corrections is going to need.
All you're doing, Judge, correct, is today you are sentencing him to 9 years on the amended call, correct?
That's correct.
The credit to be determined by the Department of Corrections.
Well, we should maybe address jail credit.
Right, that's what I'm saying.
Yes.
We
Jail
shouldn't,
can be
maybe, we
determined by-
should.
We should.
Right.
We need to, because as a practical result, we're dealing with the Department of Corrections, who is a much changed organization from what it was in 1997, much for the better. But they still have their way of doing things, and we need to do it their way.
Your Honor, I believe there's two ways we could do this, and maybe you have a preference, but one, I think we could make it nunc pro tunc to the date of sentencing, which was, I think, January 20th, 1998. That wouldn't have to deal with jail credit, it would just go back to that date. The second way,
I believe that simplicity is a wonderful thing, and the court makes this effective a nunc pro tunc of the original date.
I have that date as being January 20th, 1998. Not sure where I got that, I have that written down.
The sentencing date was January 20th, 19, I believe he was convicted December 5th, 1997. If we non-pro tunc the sentence, we're going to have to non-pro tunc the reopening and the amendment of this multiple action during today.
I'm willing to listen, Ms. Ransom, listen to how it is you can do this with the least amount of difficulty. I don't pretend this to be easy, but we need to have answers from the Department of Corrections, and we need to have a document.
Well, without putting the clerk in difficulty, Your Honor, if we do it the same as January 20th, give the same credit for time served as we received in the original judgment of conviction, and the additional credit for time served would be added from January 20th, 1998 until today's date, and that will be the actual number in there for credit for time served for Mr. Miller under the new judgment signed nunc pro tunc today, with the January 20th, 1998 judgment of conviction. At least that's logical to me.
And I think if it goes to nunc pro tunc, then you don't have to worry about it, you get credit for the days since then. As a matter of fact, there's been 5,913 days total since he was arrested, and it could be put on there, it's that much jail credit. But I think if it goes nunc pro tunc from January
This
20th.
court is prepared to, in my own hand, put nunc pro tunc on this order and put that date. Then I think
If we run into problems that they can't do that, and if it had to be as jail credit sentencing today, jail credit today, we'll try to support that, but I think,
Mr. Lifke, do you believe that nunc pro tunc is the best approach?
I'll defer to that. That sounds okay to me.
Ms. Ransom, if it can't be done, let me know now.
Well, and even if we do nunc pro tunc to that date, and just some indication so that the time period is clearly run by now would be more important to satisfy them. It may not be a normal nunc pro tunc, but we're not dealing with a normal case here, so it'd be better if they have that there in addition to it, even though it's been done nunc pro tunc. So it's kind of a belt and suspenders, Your Honor, and that
Fine.
way.
And Mr. Prey, the nunc pro tunc date is what the,
I believe it's January 20th, 1998.
Okay, are you just non-pro tunking the credit for time served? Okay, I'm gonna ask a simple question. If we're reopening today, we're amending today, we're sentencing him today to 9 years, pled 9 years, why would we not say he's sentenced to 9 years today with credit for time served back to
Pray?
I have 5,820, that's from January 20th until today. And that's what the registrar told me, I didn't put a calendar on that.
It's
Then there were-
192 today, correct?
Then there were 93 originally from the date of arrest until the date he was sentenced. That adds up to a total of 5,913 he's been in custody on this offense.
If we have both of those active, I believe that's the belt and suspenders that should satisfy the Department of Corrections.
Yeah, because their confusion was that if we have a sentencing date back then and one today, well, what we did today was we just sentenced him on that count. So there will be a sentencing date of today.
Okay, that's fine.
Right, he fled, we got the question there. Right, is that the?
Yes.
Nonetheless, Mr. Pray, what I have done in my own handwriting and order is put young approach count 12898, 5,820 days of jail credit plus, what was the other, was 93 days?
93.
I defer to Ms. Rancinici, who is a very skilled individual.
Please don't defer
She
to
is the
me.
person responsible to implement this. So the sentences today, and Mr. Miller will get 5,820 days plus 93 days of credit. Is that the entire amount of credit?
Yes, Your Honor.
Even if it is, and we so stipulate.
So everybody agrees that it's the sentence.
Yes.
Yes.
I was trying to get Ms. Rancinici to actually tell us how this can be done.
It's not me to tell you.
No, but
It's
the
not.
fact of the matter is that this is a complication that needs to be reduced to a writing, and I understand. As a practical matter, Mr. Miller has to remain in the custody of the sheriff until the Department of Corrections delivers the documents that are necessary to implement this. Mr. Miller will be meeting with the probation and parole, and those arrangements will need some time to be made properly. Mr. Lipsky, is there anything you wish to add?
No, Your Honor.
Mr. Prey, anything you wish to add?
No, Your Honor, thank you very much.
Thank you, Judge, very much.
Well, see, when I called her, she's like,
Hey, buddy.
to have two sentences, because my thought was, why don't we just put variable and then put the comment section, which is in the conviction, what found guilty at jury trial, unqualified innocent. She said, oh, I don't know, two sentences, and then the conviction. So, you know what I mean, then it, well, no, I wanna go with you guys, but just the paper. I mean, it seems, yes, because see now everything. Well, I know. And then sentence today, he's in there.
I'm not waiting.
For something happens. It's a judge's order, he said, he's sentenced to 9 years. And he's got all the credits. Yes.
funny. Yeah, he's a funny guy. Take care.
Love for you.
It's nice to meet you.
Yep. Take her easy.
Yeah, you too.
Steve.
Marty, did you want to comment on anything? Not one thing?
No, it's all in the step.
Got it?
Well, I don't know what else to say, I don't know. Or his parents
it's
didn't
over.
come?
Huh?
Parents didn't come?
Mom's here.
That's mom?
Yeah.
I'm the important one.
You're the important one.
I didn't miss one yet.
I gotta tell ya, you got a big fan in Ruha. Last name is Ruha, live on the corner.
Yeah.
She told me years ago, you gotta do something with us, okay? Get a hold of Mrs. Miller, have her come. This would have been 4 years ago. But you do have a good friend there. and a good
Yeah,
fan.
they've been friends a long time.
We have another sentencing.
Well, we were gonna let you take care of, or get a good start on that before we do
Where
this.
did they go? I need that stipulation.
Yep,
Do you have the signed stipulation? Stuff in my house.
I signed it and gave it to those guys. I never take originals. I never take originals.